Hi, everyone, and welcome to our video legal podcast, Legal Questions and Answers in Layman's Language. And a very interesting topic today is lead paint poisoning, and we look forward to getting started momentarily. Hi, I'm John Deary, and we are very happy that you've joined us in this podcast. I am very honored because he is a friend and a very outstanding attorney in a whole range of areas. We're going to talk about lead paint today. But he is with the firm that's a very prominent firm and well known, and that is the Salino Law Firm. And he does a lot of litigation and a lot of work on a range of issues. We're going to talk today about, as I said, lead paint, and I'm delighted to introduce Casey Fundaro.
Well,
Casey,
John,
what a pleasure.
It's wonderful to be here, and I'm honored that you asked me.
Well, I am happy that we did, and let's start by giving maybe a general sense with regard to the issue of lead paint.
Well, the issue of lead paint goes back to what is a landlord's, responsibility to its tenant, right? In New York, if you live in New York City or around the five boroughs, or even in New York State, but there's a non-delegable duty. In other words, that means is you can't shift it on somebody else. A responsibility to maintain your premises, to maintain the room, whatever.
Let's go ahead. Go ahead. That's right.
Sorry.
That's all right. Sure.
You have a responsibility to maintain the premises. What that means is that they can't rent you an apartment that has issues or that's dangerous. Now, here, when you're talking about lead paint, one of the main issues about this duty to maintain is whether or not the landlord would knew about this. Did they know when they rented you the apartment that it had some semblance of danger, and how would they know that? Well, many times apartments in New York City are older, and an older apartment, it's almost guaranteed that lead was part of the paint that was painted on. So would they know about it? Well, they should. They should know that it's lead. So when you have an older building, if there's an exposure and it hasn't been painted in quite a while, or even it's been painted over numerous times, there is a risk of exposure to lead paint. When it chips, if a child gets a hold of it, they can put it in their mouths and whatever, and it can be a very, very serious problem. But they have a responsibility. One of the other ways that you could conceivably determine whether they knew, right, that it was previous, that it's an older building, you have renovations, right? So when you renovate, most contractors will know when they are dealing with a lead paint situation, and they'll go in and they'll sand and they'll say to the owner, you have a lead paint issue here, and it has to be what they call remediated, right? And again, that's notice. It all goes to, what did the landlord know? Did the landlord know that there was a potential lead paint exposure? And certainly this is important for adults, also very much for children. You have to make sure that they are protected. So
what is the responsibility of the landlord, in fact, to know whether there is lead paint in the walls?
They have to know, because ultimately when you say what is their responsibility, they like I said, it's a non-delegable responsibility. They can't turn a blind eye and say, we didn't know that there was lead paint. Well, your building is 50 years old. It's 60 years old. Every wall that's painted 50 years ago had lead paint in it. They should know this. When you do a renovation, when the contractor comes in, they want to know, is there lead paint? They test it, and they don't want to be near it.
At what point does the landlord have the responsibility of conveying to a new potential tenant that they believe that there's lead paint? Do they have to make that affirmatively, or do they wait for some problem to develop?
Well, they do. I think I think in most standard leases in New York City, there is a clause that says that the building is older. There could be some exposure to lead paint. At the end of the day, whether or not that's actual notice, I'm not really sure. Whether you're telling a tenant They're going to 15, 20 apartments. You're trying to find a place, and every standard lease says there's a possibility of lead paint. That's true. Why? Because if the building is older, it's there. But just saying it might be there isn't enough. They have to fix it. You just can't rent an apartment and know that the apartment potentially has a lead paint issue and expose tenants to that kind of risk.
So you have a situation where there is an apartment.
Mm-hmm.
The landlord knows the apartment is going to be rented to Mr. X.
Mm-hmm.
When Mr. X comes in, if the landlord suspects that there's lead paint, what is his responsibility at that point?
Remediate. In other words,
what does remediate mean?
Remediate means, and again, we want to talk in layman's terms, fix it. Fix it.
How would you fix it? Meaning what? Paint over it?
A contractor has to come in. No, painting over won't do anything because it's still underneath, right? It is somewhat of a more complex process. I mean, I'm not a contractor, but it has to basically be removed. You have to sand it down. You have to make sure that, if you're a worker, that you have equipment so that you don't inhale it, so that when you go in there, there is no lead. The lead's gone. And again, there are some contractors that are professional in terms of remediating lead and lead paint. So it's a specific thing that some contractors do.
There is always a very severe concern for children and lead paint.
Mm-hmm.
Is there any particular requirement on the part of the landlord if he knows that a family's moving in and there are 3 teenagers or younger than teenage children?
Well, I think that certainly with children, a landlord should be more vigilant, right? They should be more careful. They should want to make sure that they protect children. But I think that the responsibility is to people. I mean, it's to adults, it's to children, it's the same. You can't expose your tenant to lead paint. Can't do it. And if they either knew about a lead paint issue or they should have known about it, that is a violation of their non-delegable duty to the tenant there. And it's significant, and
it's a serious responsibility they have, isn't it?
It is. It is, and it's somewhat consistent, or it's the same thing. Not to go off on a tangent on anything, but they have a responsibility to maintain the property, right? They have a responsibility not to have a hallway that has cracks in it that you could trip on. It all goes to the same thing. The legislator, when they created the laws, they said, well, the landlord is the one that's making the money from the rent. They need to, in exchange for that rent, give a tenant, give those that come upon their property a reasonably safe place. Now, lead paint is poisonous, and I think that we were going to discuss some of that in terms of how does that detected? How do you know? At the end of the day, maybe if you have a child, God forbid, and you see the child eating a paint chip or something, obviously that's something that would show exposure. But you never know. I mean, God forbid your child is showing signs of, again, maybe they're not doing so great in school, or maybe they don't have a good attention span, or maybe they have headaches. Well, sometimes you think, oh, that's just children, but it could be a situation. If you have a pediatrician, you tell them about the symptoms. Pediatricians in New York City are very sophisticated. They will consider the potential for lead paint exposure, and there's blood tests that you can do to determine it. Again, I think that I hope that never happens to a child or whatever. But at the end of the day, is it just normal? Well, when you go to the doctor, you want to ask about these things to protect your child.
Let's say you're talking about a youngster, maybe there are 2 or 3 in the family, but just using the example, you have a 7-year-old,
Mm-hmm.
and the parents, the mother takes a look and sees along the shelf of a window, for example, and maybe some accumulation of crust there and chips, and she sees a child put a piece or 2 in their mouth.
Mm-hmm.
What should she be focused on trying to do then? What's the next important step in terms of doing an analysis as to whether the child has been impacted?
I think that if a child has never put lead paint in their mouth, and I hope that's true, Would that be, would that cause some kind of damage right away? Probably not. But at the end of the day, what should they do? Yeah, they should definitely take the child to the doctor and see what's going on with that. Potentially, the lead, keep whatever that is, put it in a baggie, do something with it, and have it so that it could be potentially be tested. I mean, ultimately, and this is important, I think, to make sure that this is clear. You are the tenant. It's not your job to test the paint. It's the landlord's job to test it. Okay, so yeah, you can put it in a little bag and whatever. Do you need to send it to a lab? No. No, they have a responsibility not to expose the tenants that are paying rent to lead. They have a responsibility not to allow, trip and fall hazards in their, common areas in their lobby. They have that's their legal responsibility that they can't pawn off on a manager, or they can't pawn off on, say, well, it was the maintenance company that was supposed to do it. Oh, it was the painting contractor that should have caught the fact that there was lead paint in there. No, no. It is the owner of the building's responsibility as a matter of law.
It is my understanding that, again, if you have a youngster who you believe has in fact ingested lead paint, that the city of New York is very aggressive in terms of not only urging that the family brings the youngster to be tested, but also very aggressive in terms of getting into that apartment and getting rid of the lead paint on there.
Well, that's true. The city of New York will go in and they will, test. They will order remediation. They'll require that the landlord pay for this. New York is, I think, unique in that regard. They do have programs, and they're cognizant of the problem because of the age of the buildings, because of the fact that there are so many tenants and so many apartments in New York. They're on top of it for the most part. So yeah, if you notice that, you can contact the city, and the city will come in and they will do an inspection. And again, if it shows that there's lead paint exposure, you probably want to figure out a way to maybe temporarily relocate. And again, this is all of these things I'm talking about. I want to make sure it's clear. You're being forced to move. The landlord has the responsibility to make sure that this does not happen. You're not supposed to be thrown out of your house because there's lead paint exposure. So ultimately, hopefully your landlord is on top of it and it never happens. I hope that anybody that's listening to this, you don't have this issue. But if you do, yeah, there are remedies, which is legal remedies. We can sue. You can sue. You can contact the city of New York. They can fine the landlord, etc. But ultimately, the biggest concern primarily is to your health.
For a tenant to file a complaint with the city of New York, one of the numbers that they can do that directly on is 311.
Right.
And maybe worth talking about the importance of that.
Well, the 311 system is unique to the city of New York. It allows anybody to make a complaint. It can range from, like we talked about, the potential lead paint exposure, garbage, and vermin. It's unique. And when you make a complaint, there is usually a department within the city that is responsible for those things, and they come out and they'll give the landlord a violation, which would require it be fixed within a certain period of time. If they don't fix it, they can be fined. Very frankly, they can come in and they can condemn a building, and they can say everybody has to move out. I mean, they have a lot of power. And
you mean the city of New York?
Yes. So
I think I get the impression that the city often has responsibilities to be responsive to issues of concern, such as lead paint. But I have a feeling that they are particularly sensitive to this issue of lead paint.
I think, John, that's true. And I do want to make a comment about something. And I'm here. I'm with another law firm, but full disclosure, I was at one time an employee of yours here, and what I know about this law firm is that what your areas of expertise are. One of them is exposure cases. Now, as I'm sure that if you went on your website, you could see that you were very involved with the World Trade Center cases, and a lot of those cases involved exposure. A lot of it involved doing testing to determine what kind of impact it had on people. This is somewhat the same thing. And again, I'm here to talk about the subject, but what I think I want to make clear for your listeners here and your viewers, I think that the Deary Law Firm is unique in this regard. I think that when it comes to a lead paint issue, when it comes to an exposure issue, they do have the experience, they have the knowledge, they understand how to read the medical records to determine what type of exposure exists. They understand everything about dealing with the city of New York in terms of complaints. They really are, they're a leader in New York City. And I want to make sure that I say that here.
Well, thank you. That's very generous of you. Thanks a lot. And I remember with great positive feeling the years that you were here as member of our team. Believe me, Casey. When you talk about relocation, now that's a very challenging thing. Family is in a particular building for several years, and the family is accustomed to all of the dynamics of that building.
Mm-hmm.
And if they're faced with this, if they don't get that remedial action and get that lead paint out of there, the notion of relocation is really a tremendously challenging one.
Well, I mean, very frankly, it's expensive. Where do you go? I mean, what are you going to do? Are you going to move into the Plaza Hotel for 2 weeks? It's not something that the average person has the finances for. You may have children, they're in school. It's a horrible thing. I mean, ultimately, if it's bad enough and you have to relocate, it has to happen. That's all recoverable damages. If you wind up having to spend money, that would be part of a lawsuit down the line that you had to pay that extra money. A lead paint exposure situation, if you're tuning in, and I hope that honestly you're not here because of that. I really, it's a horrible, horrible circumstance to be in. Yes, landlords have really very significant responsibility. It's not your responsibility as a tenant. There are a lot of great landlords in New York City, and they are very cognizant of it, and you are very safe. But there are some that you aren't.
In terms of making a complaint to the landlord, verbally or in writing, which do you recommend?
Well, you need to make the complaint in writing. If down the line you have to go to court and you talk about, well, did they have notice of the problem that we keep talking about? Did they know about the problem? Should they have known about the problem? Well, if you send a letter to the landlord and say, we have paint chips that are on the windowsill. Our child was diagnosed with developmental delays or something crazy. That's notice. That's written notice. Now, I think in this day and age, in terms of what is written notice, and I'm going to talk about that just one moment,
Please.
You'd think we talk about 311, the 311 system. To protect yourself in this circumstances, just be aware that making a complaint through 311 would not be a legal notice. That it sounds crazy that'd be true, but that's true. And under the cases that are out there, just contacting 311 is not enough. So what should you do? You should certainly write the landlord. And this is a little tip that I would suggest for any tenant. Always remember you have a property manager that you deal with. You send them the rent. Smith and Sons is the managing agent. Well, you can send an email to them. You can send a letter, maybe even a certified letter, so that you have proof of delivery. But you can ask the managing agent, who's the landlord? Who are they? It's John and Jones Company, Inc. What's their address? Well, they give you the address. You send the letter to the property manager, and you can send it right to the landlord too. Why? Because they're both defendants down the line, and they can't then say, we didn't know, the property manager didn't tell us. The landlord didn't tell us. No, you told them both, and you did it in writing, and you have proof of delivery.
If it gets to a case where it goes into litigation, what kind of compensation and how does that compensation process work with regard to an individual tenant who's lived and has had, let's say, two children that have been diagnosed, in fact, with lead poisoning? How does that work?
Well, you talk about the standard damages in an injury case. You have pain and suffering, which is, I always, when you talk to a jury and you say, well, what's pain and suffering? It's ouch, it hurts. You have what they call loss of enjoyment of life, where your life is different. But, to really kind of just come down to, let's say, God forbid, we're talking about a child. Well, you have medical expenses with regard to all the, the issues that relate to the lead poisoning. In that case, those medical expenses in the past could be significant, but in the future, if you have a developmental delay situation, you have all sorts of occupational therapy, you have physical therapy, you have potentially neuropsychology. Point being, we keep it simple here. A lot of doctors and a lot of money, and it costs a lot. So you put that together. If you were to bring a case, that part of the case, past medical expenses, future medical expenses. And, when you're dealing with a child too, you're talking about potential. Mom and dad may have a certain career. And the child is, maybe the child showed some great promises, in elementary school. Maybe, you learned that this child was very bright, and now they're robbed of that. Okay, so that's part of it. That's part of it, the delays. And again, pain and suffering, which is something that you can't quantify with money. And then you have dollars, which is the medical expenses and possibly, issues about how they can earn a living, whether it's a girl or a boy, down the line. It's all part of the damages.
Yeah, I mean, you've got medical bills, you've got lost wages, you've got emotional distress,
Right.
Funeral expenses, unfortunately, in that kind of a situation.
Well,
So those are compensation matters that.
I mean, if I may, just quickly, when
Please.
you talk about, you see, one of the things, and I say this with my hands like this, praying that you never have a circumstance where somebody passes.
Yeah.
I've had the privilege to represent families that have had family members that have died. There's different kinds of damages in those kinds of cases, and we don't need to get into it too much, but it's something called wrongful death. Wrongful death is something that basically says, well, it's economic damages. What was the individual, the father or whatever, he was taking care of the kids. What did you lose? What was he making dollar wise? And then you have what they call normal, in this case, where you're before the person passes, what they call pain and suffering, which would be the standard case that's not involving a death case. But what I can assure the listeners is this. The Deary Law Firm has a lot of experience. The damages in these cases have to be quantified. I know because I have been associated with the firm. The firm hires excellent experts to evaluate those things if necessary, so that you get complete full damages for something that's horribly tragic like this.
Very important in this area and any area that we touch on, and we always want to come back and speak about the statute of limitations.
Well, statute of limitations is 3 years in New York for any injury.
From what
claim.
point?
Well, in an exposure case, I think that it would be from the date of discovery of the lead paint. There's cases on it that talk about, well, it was the paint job went on in 1956. Well, no, I mean that's not going to be the commencement of the statute. But ultimately, if you send a letter to your landlord and say, well, there's a paint problem, there's a lead paint issue, that would be likely a moment that the statute started from that moment.
When you talk about the special rules for children as it relates to statute of limitations, I think that's quite important.
It is. It is. One of the things that you have is that when a child, obviously, a child does, the statute of limitations on a child does not run until that child turns 18. So in the horrible event that you find out that your child has had developmental delays or some type of exposure and poisoned by lead paint, and you suspected it when they were 3 years old, and now they're 8, 9 years old, and it's been way past 3 years. You shouldn't worry. You don't have to worry because you can bring the claim within 3 years of your child's 18th birthday. And again, I keep saying this, hope that would never ever be the circumstance, but yes, 18 is the time when the statute of limitations starts to run.
With regard to the lead levels in blood, there is a blood level quantitative number that is important, I think, for people to understand.
Yeah, it is. I think, again, I'm not necessarily certain of the number. As a matter of fact, I think that you know what the number is. What is the number? Do you have that?
I don't.
You don't have
There's for children, there's 5 micrograms per deciliter or higher,
Mm-hmm.
and pregnant women, any level requiring medical attention, and for adults, it's 10 micrograms per deciliter or higher.
Yeah, I mean,
those are the qualifiers.
Yeah, I think those are the qualifying numbers. I mean, in terms of that, it's going to have a certain toxicity and it'll have an impact. But I would go so far as to suggest to you that any exposure is too much. You can't be exposed. A child, an infant, a toddler that is exposed to lead paint, it's poison. And they cannot be exposed to it. You could have a very limited amount of exposure for a very short period of time, and it could cause irreparable harm to a child. So again, we talked about New York's focus on it. There's laws to protect people. Very frankly, a lot of landlords, like I said, in New York, are very vigilant about it because they want to rent safe premises. There are the exceptions, and I hope that you never have that situation.
What advice might you give to tenant X who has 2 children and is looking for the need of an apartment, finds an apartment building that they're reasonably comfortable with? Mm-hmm. What do you recommend they do or be thinking about in terms of the lead paint issue relative to the landlord and their decision?
Well, I mean, simply, it's a question. Is there lead paint in the apartment? Ask them, right? Was there ever lead paint in the apartment? Did you remediate lead paint? I mean, the building is older, right? If it's older, are you just painting over it? Are you sanding it down to the drywall or whatever older building to the plaster and getting rid of it, right? What do you know? They have disclosures too, I believe, that they would give the tenant that there's a potential for it. Ultimately, you have to just ask them. I think that's probably the biggest thing, and be aware that if the building's older, the chances are that there may be some lead paint issue there, but ultimately, again, you have to ask them. You have to ask them, and I do think that there are some statutory disclosures that they need to make when they rent the apartment.
Maybe you'll say a little explaining on a number of the problems for children that may have been exposed, and that is developmental delays in the children's growth and education.
Right. Well, what we know about children and developmental delays is that it's a burgeoning area because the brain is it's a very misunderstood, and we're just learning now about how the brain works. When you have like literally, this is a poison that impacts a child's brain. It doesn't develop the way it should. It's a situation where a developmental delay can be determined by treatment. You go to your pediatrician; they would refer you to maybe a pediatric neurologist to
Well,
determine.
there are learning disabilities, I think, also that go along with this.
Well, there's many people that suggest that there are learning disabilities where you have it leads to there are learning disabilities that come directly from the exposure.
Another general area that I think parents should be cognizant of is muscle weakness.
Mhm.
If there's any deterioration in the mobility of the child.
Right. I mean, there's a lot of different warnings that the parent might get that there's an issue. The bottom line is that there's things like as for example a baby or a toddler, it's like rolling over. Is it taking your child too long to learn how to walk? Is their ability to speak delayed? Is their ability to be potty trained delayed? We all, I think, as a parent, I'm a parent. You want to know, well, what is it that it's too long, right? Well, you ask your pediatrician, right? Doctor, is this unusual? You know your child better than anyone. So make sure that you explain anything that you see that's out of the ordinary, and they will diagnose it, and hopefully they can send you to appropriate specialists to determine it. And again, you know your child best. So if it seems unusual,
a couple of the other areas that I think people should be cognizant of are mood disorders and weight loss.
Mhm.
Those two items I think are of some importance for parents to be cognizant of.
well, I mean, a mood disorder certainly. If you're talking about your child was exposed to lead paint when they were small, an infant, and you have a 15-year-old or a 16-year-old, 13-year-old, 14-year-old. There's a difference between a teenager who's having a bad day and a teenager who has like a chronic manic depression. Okay, if you don't have any evidence, any past history in your family of any kind of mental illness or depression or anything like that, and your child is in their room and they don't come out and they don't feel like they want to go to school and these types of things, and there's no other external factors that relate to that, that's not normal teenage behavior. What your child, what your child's normally like. If they go into that kind of they exhibit those types of things, again, the pediatrician is your best option. Explain, look, these are the symptoms. But yeah, a mood disorder is certainly something that can come from exposure to lead paint because it's poison. And remember, a mood disorder, the source of the mood disorder is your brain. It's brain function, and it's actually what they call physical in your brain. There's something in your brain that's changed because of the exposure to poison.
I appreciate greatly. This is a serious issue and matter for thousands and thousands of people moving into apartments today, tomorrow, and the next day.
Mm-hmm.
So that whole notion of asking at the outset to the landlord about the issue of whether there's lead paint, I think that's a very good practical way to start this analysis.
It is. And again, I think that what I think is somewhat interesting. I may ask you. You're from New York, right? You know
A place called the Bronx.
Yeah, you're from the Bronx, and you've lived here. You know that the landlords, the painted walls, and there's lead in those walls, right?
Yeah.
And it's not like it's a secret. Landlords know. They have a responsibility. They are aware of it. Ones that don't take the responsibility to do whatever they're doing, it's not okay. If God forbid anything happens, they need to be held responsible. And I know that if that ever happened, go to the Deary Law Firm, and they certainly would protect your rights, do what they could do to help you, and get you maximum compensation for an injury such as this one.
Casey, we wanted to know about lead paint, and you told us about lead paint poisoning. and it's a pleasure to be with you. Thank you so much for your time.
John, it's my pleasure. It was my pleasure to work with you and to know you.
Thanks.